I'm Jeff Butler, and this is Tom Giannotti of the Butler Law Firm. We're here today to talk about a case that Tom principally handled arising out of an apartment complex in South Georgia.
So what happened in this case?
So this is a case where our client was a young lady who's a tenant at an apartment in Albany, Georgia, and our client was moving into an apartment. She was, as part of that process, was filling out an inspection report when she noted as part of that inspection that the downstairs bathroom mirror appeared to be loose. So she notified the apartment owner, the property manager, to fix that mirror, and they told her it was fixed. She didn't find out until about a year later that in truth it had not been fixed, and she went to go clean it one day, and the mirror fell on her, badly cut her hand, and resulted in some serious nerve damage.
And this wasn't just like a normal cut, right? I mean, the mirror comes down and like slices her hand. She had, was it damage to the nerve? It didn't get the tendon, I don't think.
No, it got the nerve between her, on her left ring finger, and she actually had to have surgery. It was about 3 days after she went to the ER, she saw a specialist hand surgeon who actually had to do skin grafts as well as a nerve graft, which was basically taking a nerve from another patient, essentially, and inserting it in the section of her finger where that nerve was, the nerve endings were missing, essentially, or had been cut.
Did you file a lawsuit in the case?
We did. We actually filed a lawsuit, and we named two entities that were two companies that were we thought were the property managers. We'll explain why that is in a minute, but essentially one of the companies that owned this complex actually went into what's called a default judgment.
And what does default mean for a client?
A default judgment is basically when the defendant doesn't answer the lawsuit. There's a certain period of time that the law says the defendant has after they've been served to file an answer, and this company just did nothing.
What do you do?
And so let's talk a little bit more about that. I mean, so what that means is that whenever an individual or a company is served with official lawsuit papers, usually the complaint and the summons, and when our office does it, discovery requests at the same time, at least in state court, then you have to respond. The person or the company has to respond within 30 days. And if they fail to do that, they enter what's called default judgment. They've got 15 days where they can come out. That's what we call it, come out of default, like fix the problem automatically. They have a right to come out of default for 15 days. After that window closes, they're usually held in default by the court. And that means they can't come out of default unless the court allows it. But the significance is in what that establishes. In any tort case, in any personal injury case, the plaintiff or the person who's hurt has to prove liability, that someone else did something wrong, causation, that the wrong act caused harm, and third, damages, that is, what was wrong. And default proves two of those three.
Mm-hmm. Yes, essentially, liability is, for our purposes, admitted by the defendant based on their failure to respond, and that just leaves the question of damages.
So when a defendant's in default judgment, as the apartment complex was here, they can no longer claim that they acted correctly. The court finds as a matter of law that they were negligent, or whatever you wrote in the complaint, the start of the lawsuit, is presumed true because they didn't answer it in time. And the same for causation. Sometimes a defendant will want to defend a case by saying, oh, I did something wrong, but that isn't what actually hurt the plaintiff. They don't get to do that if they're in default judgment. So we were really excited, frankly, when the defense failed to answer and entered default judgment, because it's great for our client. Simplifies the case.
Yeah, and it just allows us to go and pursue what they call unliquidated damages, basically go prove up our client's damages, like her pain and suffering, her medical bills, the extent of her permanent injury, etc.
Yeah, so all that's left is damages.
Right. So we thought that was really great for our client, and it really kind of put once the apartment owner eventually realized they were in default, I think they were kind of running scared a bit. They were trying to get us to agree to reopen or to the default judgment.
Right.
Yeah.
We politely declined.
So, but basically, we ended up in a fight with the court about this. They ended up, because we wouldn't agree, they basically went and asked the court to reopen it. And the law in Georgia is modernly a little bit open on that question. There's some recent Georgia Supreme Court decision that we weren't really sure how the court might rule on that, but we thought we made a really good argument. And actually on the eve of the hearing, the court set on this motion to open the default judgment. The defense finally agreed to settle the case for a substantial amount that our client was happy with.
Put a little of that in layman's terms. So we had them dead to rights because they failed to answer within 30 days, and then the 15-day grace period was gone. So the court held them in default. And then, as Tom says, the defense tried to get out of it, which means they filed a motion to open default judgment. It's a formal request for the court to, forgive them for not answering on time. And we filed our brief that said, no, cowboy, you don't get to do that. And we were right. But there was some recent appellate law that made that made us a little bit nervous. But anyway, we had, as Tom said, a hearing set. Now, a hearing just means it's when you actually go to court and stand before the judge and say, Your Honor, we asked the court do X or Y, and these are the reasons you should do it. And it was the day, right before that, they started getting pretty nervous, decided they wanted to talk settlement. And as Tom said, we reached a number that our client was happy with. At the defense's request, the number is confidential, so we can't say it on the video camera, but it was good.
I think that's the last part. You kind of answered the last question.
Okay. So what do you think, Tom? I mean, after working through the case, are you happy with the result? Do you feel like we did well by our client?
Yeah, I think we did. It's always really great to see a happy client and someone who's gone through so much get justice. And we hope that the financial settlement we secured is some small measure of justice for our client, who's going to have to deal with this injury for the rest of her life.
Tell us what she did for a living. It kind of shows why that injury mattered to her.
A couple things. One, we knew that our client was employed as a housekeeper at a hotel in Albany, and so I talked with her supervisor, and her supervisor had only great things to say about our client's work ethic. Said our client even tried to come in and work with one hand, trying to find things she could do with only her right hand, and it just wasn't working out. And so they said, you need to stay home. She eventually, the injury was, she kept having issues with that nerve injury, and so she ultimately had to change jobs to a position where she was more able to manage with that injury. The second thing is we met with her treating surgeon, the hand specialist who operated on her nerve, did the nerve graft and skin grafts, and he wrote a report that explained what he did and why, and essentially for purposes of proving the damages portion of the case that we talked about was really crucial, because that would be admissible at trial and could be read as part of evidence in the case. A doctor was able to give his opinion as to the fact that our client would never regain the full normal sensation that she had pre-injury in that hand.
That's something the Georgia Code calls that a medical report under OCGA, or Official Code of Georgia Annotated 24-8-826. Some people call it a medical narrative. The law calls it a medical report. It's something that Tom did a great job of in this case, and I think that we as a law firm institutionally do a good job of. And it's a very powerful thing, because you have there the doctor who went into her hand, and connected the nerves and things, talking about, this is what I did, this is what she had been experiencing before, and this is what the future is going to look like. It's better, but it won't be totally back to where it was. So it was really powerful. Another brag on Tom for one other thing Our client left him a glowing review. We did a Zoom call with her the other day and recorded it, her sort of video testimonial about Tom's work in this case. So we'll post that on the same blog post where we post this. He did great work and she really appreciated it, and that always makes it worthwhile.